Hi, I'm Janice Mumberson, and I'm here today with Nadine Finbow, a lawyer from Barriston Law who practices in the area of family law. Hi, Nadine.
Hi, Janice.
Nadine, in the circumstances where a child has a definite opinion about which parent they would like to continue to live with, how do they put that information in front of the court, or how does the court take that into consideration?
The views and preferences of a child are important with respect to determining their best interest under both the Divorce Act and the Children's Law Reform Act. In certain cases, it's appropriate for a child to provide their views and preferences, and many people ask if there's a certain age. There isn't. However, it depends on the child's age and maturity and whether they are able to provide independent views and preferences. If the court is of the view that their views and preferences are necessary to determine their best interests, the court can seek the involvement of the Office of the Children's Lawyer, which could appoint either a children's lawyer on the behalf of the children to represent their interests in court, or appoint a clinician who would make an investigation into the best interests of the children.
So what does that look like in terms of how the Office of the Children's Lawyer advocate gets involved, or how the clinician gets involved? Do they meet with the child directly?
Yes. The children's lawyer can be involved in one of three different ways in terms of decision-making responsibility and parenting time. The children's lawyer can choose to appoint a lawyer to represent the children's interests in court and speak to the children's views and preferences in court. The children's lawyer could also appoint a clinician to provide what's called the Voice of the Child report, in which case they will provide a report to the parties and to the court, but would not appear in court on behalf of the children. The children's lawyer may also appoint a clinician and a lawyer to provide a full investigation. In any of these situations where a children's lawyer or a clinician is appointed, they'll meet with the children on at least 2 separate occasions and sometimes more in order to ensure that the children's views and preferences are independent and haven't changed.